Approaching to my right. Ms. Jackson, please state your name for the record.
Nikita Jackson.
Thank you.
This is the day and time set for preliminary examination. The people are ready to proceed. I did have two preliminary matters. The court would be willing to address those first.
All right.
First would just be, I don't know if the defendant intends on calling any witnesses. The people have only two witnesses that we intend on calling today. I would ask for mutual sequestration to be ordered.
Objection to that.
Objection.
All right. Witnesses are hereby ordered to question.
Thank you. And the second issue or matter, your honors, I would be requesting if the court would permit to turn off the live stream camera that faces the witness box. These are law net officers that often do undercover investigations. And so for their continued safety, I would prefer if we could keep them away from the cameras as much as possible.
Understood.
No objection.
All right. We're going to lock it.
Sir.
Excluded. All right. Very good.
Thank you. People will call Detective Kesler and I'll go get him from the side vestibule.
Hold on. What did you say?
Camera on you first.
And then as he walks in, then we'll put. All right. Very good. Sir, please come forward and be sworn.
Where you take seat, raise your right hand. Do you solemnly swear upon the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, self together? I do. State your first and last name, the record, please.
Matthew Kesler, MATTHESS.
All right. You may inquire.
Thank you. Good afternoon, sir. How are you doing?
Good, how are you, sir?
I'm just fine. Sir, how are you employed? In what capacity are you employed?
I'm a detective, science, the Michigan State Police.
Is that commonly known as LawNet? How long have you been working with LawNet?
I went out there in January of 21, there till October, got pulled back to road for staffing, went back to LawNet in March, April of 23, been assigned since then.
How many years of law enforcement experience do you have?
I'm in my 16th year with Pittsfield Township, and I served with the city of Ypsilanti for about 2 years previously.
So 18 years total, if I'm doing that math right? All right. Have you ever investigated drug trafficking or suspected drug trafficking?
Yes.
What sort of investigations or trainings have you done on that issue?
Multiple trainings prior to Milana. I was a road patrol officer and was able to conduct street level forensic investigations and into the MSP investigation school. Any other trainings that worked with Milana.
I want to turn your attention to February 29th of 2024. Were you working on that day? What were you doing that day? What was your title at that time? And specifically on that day, what were you doing that day?
We're surveilling 40 Jackson.
Where were you conducting the surveillance?
We conducted this surveillance in Washington.
At any point, did you ever go to 7573 Roxbury Drive? When did you go to that location? Why did you go there? And just for clarification, do you know what city or township that address is in?
Township, Washington.
Do you know what sort of address that is? Is that a home, buildings? Right. Do you know who the title owner of that property is or who owns that property?
Title holder?
Do you know who owns that property? Right. When you arrived at that address, what did you do?
We not announced our presence. Corey had been previously detained, so we president. Jackson came into the door.
Do you see Nikita Jackson in the courtroom today? Can you please identify by an article of clothing that she's wearing?
White blouse and an overcoat.
The record may reflect the witnesses identified the defendant.
Record shall so reflect without objection.
When you first made contact with the defendant, where was she?
She opened the door.
And this sort of building, can you describe sort of the layout of the building?
So when you go in the front door, there were stairs. To the right was a room. To the left was a room. And you kind of went just to the went up the stairs and took you into the living room slash kitchen area.
So there's multiple stories?
It's a two-story.
Gotcha. What did you do when you made contact with the defendant?
We advised while we were here, her son, Cameron, I believe, was coming down the stairs. We asked him to go in the kitchen. Search the house for other occupants. I explained to her this while we were there.
Did you ever inform Miss Jackson of her Miranda rights? What did she say when you informed her of her rights?
She went then had a conversation.
All right. What was the nature of that conversation?
Yeah, I called her, she got her arrested, she wanted to go, I told her her Miranda rights. Asked her for drugs and guns in the house, talked a little bit about her son, Corey, who was the main suspect in this investigation. We talked a little bit about how he had previously stopped over starting this investigation.
Did you ever discuss or who all lived in the house with her, the defendant?
Yes, it was her and her two sons.
Did she advise who stayed in which rooms?
She told us which one was Cameron's room, which one was Corey's room, which one was her room.
So which one was the defendant's room?
If you go straight up the stairs, his was just off the left. Was sorry.
Yes, Miss Jackson.
If you go up the stairs, you go right, kind of go down that gangway for lack of better words. Then to the right is her master bedroom.
What happened once LawNet investigators made entrance into the home? What happened next in the investigation?
So once the house was secure with occupants, I stayed in the kitchen, other detectives searched the residence. I spoke to Ms. Jackson, and I was in charge of maintaining the evidence log, collecting the evidence, and putting in evidence bags. And then after that, brought it back to the office.
Were you ever presented any items of evidentiary value by Detective Sergeant Macintosh during this search? What did Detective Sergeant Macintosh provide to you during this investigation?
Provided multiple pieces of evidence by Bill.
And how did you log those items? How do you keep track of them?
So he gives it to people, all detectives me. I put it in a evidence bag, evidence log that says what the item is, what room it was found in, where in the room was found it.
And specifically, did you ever have an item number 36?
Yes.
What was that item? And who provided that item to you?
Detective Sergeant.
Did you ever send that item to be tested for anything? Showing defense counsel has been marked as people's proposed exhibit 1. May I approach the witness?
You may.
Sir, name was marked as people's proposed exhibit 1. You can take a look at that, and I have a copy for the court as well.
Yes.
Do you recognize this document?
Yes.
What is it?
It's the lab report from Fulton County Sheriff's Forensic Science Lab.
And looking at this report, is this a fair and accurate copy of the report that you received from that lab as it relates to this investigation?
Yes, sir.
People will move to admit what's been marked as people's proposed exhibit 1 into evidence.
Any objection or voir dire?
Objection for exam purposes, Your Honor.
Exhibit 1 is admitted.
So, sir, looking at this document, what on this document shows that this report relates to this defendant?
On the top is the case number and the associated individual.
And you said that you received an item 36 from Detective Sergeant Macintosh, is that correct?
Yes, sir.
Does this document say what that item tested for?
Yes, sir.
What does it test positive, or what did it test for?
GC/MS and GC testing of 1 tablet revealed methamphetamine scheduled to total weight of tablets equals 0.065 grams.
And just like that, we hit the legal battleground, probable cause. This is the threshold that decides whether the case even moves forward. But here, that's where things get interesting. The defense is about to challenge the very foundation of this investigation. If the search warrant was based on weak or misleading information, everything discovered after that could be at risk. So the big question is, was this investigation solid or built on shaky ground? Here is where the prosecution starts to feel confident. Lab results. Scientific evidence like this can be powerful, especially in drug cases. But don't overlook the detail. We're talking about a relatively small amount. So the real question becomes, is this personal use or enough to suggest trafficking? Because that distinction can completely change how this case is charged and argued.
Like a 6 to 1.
Well, I believe you said 0.065, but it's 0.65. Is that correct?
0.65.
Thank you. So you said that you've investigated narcotics and narcotic trafficking before. Is that correct?
Yes, sir.
Do you know what the typical use amount is for methamphetamine?
I mean, typically, there's several pills at a time. People who deal narcotics have thousands of pills, that hundreds of thousands.
Okay, just 1 second, please, Your Honor.
Right.
Detective Kessler, prior to February 29th, 2024, had you conducted any surveillance of Mr. Curtis? Yes, Roy
Yeah.
Curtis. In how many days? And when you were conducting that surveillance, did you put that in your search warrant affidavit?
Yes.
Okay. And your search warrant affidavit largely contains information from the initial stop that you referenced in your prior testimony, but you were not at that initial stop of Mr. Curtis, correct?
Stop that occurred before we executed the search warrant,
That's correct.
and that stopped that. I was part of the surveillance team, but I did not get out with Trooper Schreiber on the traffic stop.
Actually, I'm talking about the stop on February 10th, 2024.
That part, that's all. That then stop is what initiated it.
And so the information that's contained in the search warrant affidavit, the first several numbers, where did you get that information? The first several numbers that reference the stop on 2/10/2024 from their report.
Those, I'm not following.
So you,
Talking about the paragraphs.
the paragraphs in your search warrant affidavit. And so the information contained in those paragraphs from the stop on February 10th, 2024, where did you get the information from that stop?
Wouldn't you have to show him what you're talking about unless he has memory of
I
it?
should be there. That's what you're asking.
Okay, so you reviewed that search warrant affidavit? Or did you say you reviewed their report, Trooper Sass and Trooper McNish?
I authored this.
Did you watch any of the body cam footage from February 10th, 2024? Which footage, if you recall?
Yeah, we saw. I watched it with Smith.
With Trooper Smith? Were you aware that Mr. Curtis had a valid CPL? If I said that was on the body cam footage, would you have any reason to disbelieve that? And so I know when the prosecutor asked you about what else was found, you said we found guns and ammo, correct? In the residence. Were the guns registered? And so in your experience as a law net officer, usually when you conduct these search warrants and you find guns and ammo, does the defendant typically have a CPL? And right, but you would agree if someone is a convicted felon, they cannot be in possession of a firearm.
By law, they can't.
Yes.
Possession of weapons.
However, that was not the case here, though, correct? None of these weapons came back stolen, correct? And so in an investigation to determine whether there is in fact drug trafficking is whether someone has a CPL, is that relevant information? So, in your search warrant affidavit, you list out again the details from Trooper Sass and Trooper McNeil. Would you agree that that was the foundation of the search warrant affidavit?
She did, fine.
And did you later learn that the items that were seized from Mr. Curtis from his vehicle were in fact fake drugs, for lack of a better word? Okay.
32.
And you were gesturing towards the prosecutor, so the prosecutor informed you of that. And is that relevant information to an investigation to determine whether there's drug trafficking? So in your search warrant affidavit, you state that detectives started surveillance of Curtis, and it was yourself, Wiggins, and McCallum in DeCenzo. Did I pronounce that right? Observed Curtis at multiple strip malls. Is that correct? Okay, just sitting in his car. Is that correct? And then you put that on February 21st, 2024, that Detective McCallum observed Curtis at a Shell gas station. Is that correct?
I don't have my search warrant.
Would it refresh your recollection to look at it? Okay. And so is it anything odd about a person being at a gas station in their vehicle?
You see what gas stations, they don't get out and pump gas and they just sit there when they go and just sit in a strip mall and don't go into businesses. That is to be an odd behavior.
And when, let's just talk about like the gas station, did you observe Mr. Curtis exchange any packages with anyone?
Something like you said that, what, the affidavit that was by, so I didn't.
Yes. You didn't observe anything that day. So then again, on February 29th, it stated that Mr. Curtis was parked in front of 1713 Tudor Drive in Ann Arbor. So in your investigations and investigating whether there's drug trafficking, was there anything significant about that address, if you can recall? And had you previously done any investigations regarding that specific address in Ann Arbor? And then again on 2/29/2024, you reference an address 27227 Winterset Circle in the city of Farmington Hills. Again, that was you that personally observed that, correct? And as part of your investigations, was there anything previously concerning that address in Farmington Hills?
I come to the door, exchange something, then go back in, and then he left. That address was observed shortly before the traffic stop by teenage driver. Is my caution.
And was there anything recovered from that address in Farmington Hills? And so is it fair to say that the addresses that are listed in the search warrant affidavit in the locations such as the strip mall, Tudor Drive, Winterset Circle, these are not Mr. Curtis's home location, correct? And so on February 29th, 2024, when Mr. Curtis was detained, do you know if his vehicle was searched?
That is not certain.
And so in your prior investigations and work with LawNet, has the address of 7573 Roxbury Drive in Ypsilanti Township, has this ever been an address of interest? Okay, all right, thank you.
Can you read her?
No, Your Honor.
All right. Thank you, sir. Get it back on. Hang on before you step all the way down. Can you get it back on? Now it is. Okay. Yeah, that gets. I'll take you. Thank you, sir. All right, you make all your next witness.
Full Detective Sergeant Macintosh.
Just come forward to be sworn.
Say, see your right hand. Solemnly sworn to the testimony about the truth, the whole truth, and nothing but the truth, so help you God.
Right.
Please spell your first and last name for the record, please.
First name is Christopher, last name Macintosh, CHRIS, PHER, MCI,
All right, you may inquire.
Good afternoon, sir. How are you doing?
Good.
Doing just fine. Thank you for asking. Sir, how are you employed? In what capacity are you employed? How were you employed back on February 29th of 2024?
Detective Sergeant Warrant.
How many years of law enforcement experience do you have? Going back to that February 29th date, were you ever at an address of 7573 Roxbury Drive?
Yes.
What were you doing there? And when you made your arrival at that address, what did you do? What was your role in that search warrant investigation?
Primarily the residence was service. Search residence.
All right. Did you search the residence? And can you provide the court sort of a layout of what rooms you searched in that residence?
I did a detective sweep of the base, kitchen, and mainly my focus was in the upstairs bedrooms.
How many bedrooms are upstairs?
I searched 2 bedrooms that were possible. Searched 2.
Which two, using sort of the layout of the house, what 2 bedrooms did you search?
When you first walk up the stairs, straight ahead was my portrait.
Would that refresh your recollection?
Yes.
Do you have any objection?
No objection.
It's Corey's room, and then to the right, Miss Jackson.
Okay. How did you know which room was Miss Jackson's room?
It is the main room there, the largest room there. It's filled with female items, nothing else there. She's also the room.
When you search, and just for the record, do you see Miss Jackson in the room here today?
I do.
Point her and identify her by an article of clothing that she's wearing.
She's sitting to your right, wearing a project.
The record may reflect this witness that identified the defendant.
Record shows so reflect without objection.
So just making sure I'm understanding. So you said that there's a room belonging to Corey, and then you said there's the defendant's room. Which side was the defendant's room on in comparison to Corey's? All right. And when you go into that room, can you describe the layout of that room? What's in there, or what was in there?
Large bedroom, so large bed, both sides nightstand on the other side of the bed. There's a walk-in closet. There's also another closet across from that, and a small bathroom.
When you searched that room, did you discover any items of evidentiary value to your investigation?
I did a nightstand. I discovered a pistol that was sitting there.
Which nightstand? Anything else?
Built pretty flat.
Did you present either of those items to Detective Kesler?
I did.
Which one, if or both?
Both items.
All right.
There were other items I located with other items.
And do you remember what item number the pills were that you gave Detective Kesler?
Property item number.
No. When you were searching that room, was there any items like an ID or anything belonging to Miss Jackson? What sort of clothing was in the room?
Clothing belonging to.
All right. Were there any, was there a let me rephrase this question. I'll strike that last question. I'll just move on, actually.
Okay.
Other than those 2 items that you previously mentioned, did you find any other pills?
I don't believe I found any other pills. I found other weapons, magazines.
Still in that room or in other places of the house?
In that room, located within the parts room and bedroom. In the walk-in closet.
How were the pills, the ones that you said were item number 36, how were those packaged?
They're a plastic bag, you have to twist off.
Okay.
So
So not in a prescription bottle? What color were those pills? Why did you think they were items of evidentiary value?
Pills are normally located, prescription pills are normally located in a prescription bottle. These were located in the tend to be illegal.
Just 1 second, please.
Okay.
Pass the witness.
Cross-examination.
Detective Macintosh, prior to executing the search of the home, had you previously surveilled Mr. Curtis
Yes.
that evening? Was that the only time? And do you recall what you observed when you surveilled him? You don't have any recollection of it? Would it refresh your recollection if I showed you the search warrant affidavit? Okay, may I approach, Your Honor? Only have this one piece of weird. Detective, did that refresh your recollection? So do you recall on February 29, 2024, observing Mr. Curtis? And so in your training and experience and time that you were with LawNet, that address at Winterset Circle in the city of Farmington Hills, had you ever done any prior investigations there? Is it fair to say that the unknown male that came out of the house, you did not observe him with anything? Okay, thank you. Nothing further.
You right?
Nothing, Your Honor.
All right. Thank you, sir. You may step down.
Thank you.
Right, hold on 1 sec. Okay, they got it locked on me. You fine.
And just like that, we hit the legal battleground, probable cause. This is the threshold that decides whether the case even moves forward. But here, that's where things get interesting. The defense is about to challenge the very foundation of this investigation. If the search warrant was based on weak or misleading information, everything discovered after that could be at risk. So the big question is, was this investigation solid or built on shaky ground? Here's where the prosecution starts to feel confident. Lab results. Scientific evidence like this can be powerful, especially in drug cases. But don't overlook the detail. We're talking about a relatively small amount. So the real question becomes, is this personal use or enough to suggest trafficking? Because that distinction can completely change how this case is charged and argued.
No further witnesses in rest at this time.
All right. Any witnesses for the defense?
No, Your Honor.
All right.
Your Honor, people move or bind over on count 1 possession of methamphetamine. I believe the testimony of the court heard today was that search warrant conducted at the defendant's house, and that during the course of that search warrant, 2 pills were discovered in the room, or in the defendant's room. Those pills tested positive for 0.65 grams of methamphetamine. I believe there's probable cause to believe I believe what met their burden by probable cause.
Thank you, Your Honor. Your Honor, as this court knows, from the previous preliminary examination of Mr. Curtis, those pills that were found on 2/10/2024 were essentially fake. They were not controlled substances. As Detective Kesler testified as the affiant of the search warrant, that stop was largely the foundation of the search warrant. And so, Your Honor, relying on Illinois v. Gates 462 U.S. 213, Your Honor, looking at the totality of the circumstances, there simply was no probable cause. But even if we say
Probable cause to do what?
for the search warrant of the home, Your Honor, because Detective Kesler says that the 210 stop was the foundation of the search that led to the search warrant of the home on Roxbury. But Your Honor, even if the court were inclined to say, okay, despite the pills being fake, they didn't know it, maybe it was, but even looking at the affidavit and the testimony from both detectives, there still has to be a nexus. And so the case law requires that there be some nexus. And so the probable cause requirement requires a substantial basis for concluding that the search will uncover evidence wrong. So Your Honor may say, like, okay, maybe they have that. However, it also requires a fair probability that contraband or evidence of a crime will be found in the particular place searched. And so it's interested in the limited surveillance on these 2 days. It looks like 2/21/2024 and 2/29. Mr. Curtis was essentially everywhere but the Roxbury house. And so how can we say, Judge, that these weak facts can establish a nexus? I mean, that would be a slippery slope. Again, he's at the strip mall, the Shell gas station, Drive in Ann Arbor, Winterset Circle in Farmington Hills. There's absolutely no testimony on this record of any surveilling coming in and out of the house, parked in front of the house, individuals coming. We don't have that, Judge. And so I'm relying on People v. Garvin, which is 235 Mishap 90. It's a 1999 case, Judge. And there again, it states it has to be the fair probability that contraband or evidence will be found in that.
Why wouldn't a fair probability be the very fact that he lives?
Because there's no, Your Honor, looking at the case law in cases where they have found that nexus is evidence such as, again, they observe transactions where people are coming to his house and he's walking out and there's a hand-to-hand. Your Honor, everywhere that we have in the search warrant affidavit is outside, and I understand what the court is saying. Yes, he, allegedly he lives there, but there's nothing that ties the house to any sort of criminal activity. And as stated in Garvin, fewer foundational facts are needed to support a search of a motor vehicle. So that I don't disagree with. However, when it comes to a house or a home, the standard is greater. And so based upon, again, these limited interactions that were observed, and even if we think about the
For the cases that you're setting, drug cases?
Garvin is, Your Honor.
Go ahead.
Yes. And so even when I just questioned Detective Macintosh, even with the Farmington Hills one, it's like, yeah, an unknown male comes out the house, but it's like you testified, didn't even see him walking with anything. And so these foundational facts, again, might support a stop of the vehicle, which Mr. Curtis was stopped on 2/29/2024, but it simply fails to meet the requirement, Your Honor, for a search of the home. And so we're asking that this matter not be bound over and it be dismissed.
Sounds.
Your Honor, I want to start off by just drawing the court's attention. I believe there was an argument made that the suspected narcotics originally found in Mr. Curtis's vehicle came back as not being controlled substances. That information was not learned until well after this search warrant was already done and the house was already searched. Certainly at the time that the search warrant was done, the best information they had, and what the information they had was that the defendant's son was trafficking potential narcotics. They drafted a search warrant, the magistrate approved it, they executed that search warrant. But
even if the argument that they're fake drugs is still a crime.
Correct, Your Honor.
So, okay.
Yes. And even if the court said, I think there's an argument to be made, it's not my first limit, I think there's an argument to be made that even if the court says the search warrant wasn't valid, there's still a good faith exception to that for these officers to conduct this search. I did not hear any argument against the elements of this offense being the possession of methamphetamine. And so for reasons originally stated, I would again move this court to bind this case over to stand trial in circuit court.
Anything additional?
Nothing else, Your Honor.
All right. Well, certainly there has to be a nexus, but if I were to buy defendant's argument, that means that where officers may not see the individual go to their address, but know their investigation that the individual resides at that address, that there could never be a search warrant of person's premises. Really typically, and I have not reviewed, and if you want me to review it, I will, that search warrant, but it leads them at least to that address. There's a nexus. It's important also to understand because this incorporates part of another record. There were not just a couple pills found with the defendant's son. There was a lot of pills. And certainly there may be a reason to ask where are these coming from? Where are you keeping these outside of the trunk of this vehicle? You know, when one is looking at probable cause. It seems to me that the defendant is challenging the search warrant itself, which I would be limited by the four corners of the search warrant. And I don't have a copy of the search warrant. Seems to me that the analysis that this court would go through is in viewing that search warrant, whether or not contained in that search warrant once it's prior to its signing, whether or not there's probable cause to search the premises. And that's where I think you get to the good faith that if on the face of that search warrant, there is good cause or there is probable cause and the search warrant signed, then the execution of that search warrant by the officers and what they discover, I think would be well within their rights, given all of the totality of the circumstances. That it's a good faith exception that they were going through. They were operating on what appeared to them and what was a valid warrant. But I haven't heard the defense argue before the court that the warrant itself is invalid. I don't know that that's what you're arguing to be because you haven't really said that.
Well, I mean, that is the argument, but I was a little bit in a trick bag today because I discovered that Officer Sass was not going to be here because the problem, Judge, is that, you know, Detective Kesler is the affiant, but largely majority of the search warrant is the 210 stop. And so Detective Kesler does not have personal knowledge of that stop outside of what he testified to, that he, you know, reviewed the report. He stated that he reviewed the body cam footage. But again, that was the crux of what the defense wanted to argue because there are things that are in the search warrant that are contradicted.
Was Sass at the execution of the search warrant?
No, Your Honor, not to my understanding.
Then how does that put you in a trick bag?
Because, Judge, if I'm arguing that the search warrant is invalid, and if 80% of the search warrant is from Trooper Sass, I can't cross-examine.
Well, okay, I get what you're saying, but it's saying that somebody's put in a trick bag.
No, I didn't mean to imply that it was on purpose. I didn't realize
Okay.
today, you know, when I talked to the people that he said that he was not going to be here, because I just assumed, because again, the basis of the search warrant, and that's why I questioned Detective Kesler about it, is the 210 stop. And so when all the witnesses are here and not one of them was at that stop, it's just difficult because, as I stated, there are things in the search warrant affidavit that are contradicted by the body cam footage, but the body cam footage specifically is Trooper Sass. It's his footage.
Okay, well, if you want, I don't know then. I mean, and I'm not going to necessarily frame your argument, but it seems to me that if you're arguing that that the information underlying the search warrant is incorrect, then certainly I would give you an opportunity to, I mean, you can try to get, says here. The problem becomes somebody else is relying upon that report.
Right.
They place that in a search warrant. I think I'm still then left with, if I view the search warrant and I look at the four corners of the search warrant, if there's probable cause contained within that search warrant, then the officers can act. I mean, I understand where you may want to go, but I don't know.
Right.
I don't.
No, I understand what the court is saying because the trooper SAS could testify and the court could still say that based upon the four corners there were probable cause, or that it was a good faith reliance upon, yes.
Right. And these officers, as I understand it, going back to, I guess, the first part of your argument, they have that report from SAS is what then causes the rest of this to occur. And they believe that based upon that report, they're then observations of the other individual that they need to and would have probable cause to search the residence.
Correct.
So I'm not, I hear you. I'm just not sure how I get there. I'm not sure SAS necessarily helps you. I also don't know that. I mean, like I said, I will review it. I'll review the four corners of the document, but I don't think it gets you to where you want me to be.
I understand.
All right. Okay. So based upon that, I hearing the defendant's argument, I don't, at least what's in front of the court now, see anything that is a flaw to the execution of a search warrant, nor which would lead this court to exclude the testimony or exclude the evidence that was seized at that address. The testimony in this case from the two officers indicates that they went into the bedroom, which the defendant herself identified as her bedroom. That evidence was then seized from that location. The methamphetamine was seized from there, logged in, tested, and it comes back methamphetamine. Court believes, based on that testimony, that people have sustained a burden in showing that there's probable cause to believe that this individual did commit this offense. And so therefore I would bind the defendant over on count one, on single count. As to the arraignment, you
Stand mute and leave a formal reading, Judge.
defendant and waive formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
19th at 1:30 with Judge Punky.
May 19th, 2026, 1:30 before Judge Cookie. Bond will continue. Thank you.
And the information.
Yes, if we got one in there, I think we do. Is that it for the day?
And there it is, the judge decides there's enough to move this case forward. But don't confuse this with a guilty verdict. This is just the beginning. The real battle will happen at trial, where every piece of evidence, every decision, and every argument we saw today will be put under a microscope. So what do you think? Does the prosecution have a strong case, or did the defense expose cracks that could break this wide open?